you, David. Hello, everybody. First, do we hear and see each other? Am I visible and hearable?
Yes, you are.
Yes, you are.
It's okay.
Thank you very much. So, okay, let me begin my presentation of an illiberal case of non-territorial autonomy. Now, the quite common assumption perhaps is that non-territorial autonomy is something that is supposed to serve ends that are arguably liberal, so empowering members of national or other minorities, protecting them from the whim of majorities, so to say. And I will today present an example of autonomous bills that were put forward in 1937 by the Sudeten German party in Czechoslovakia. And this lesser-known case of NTA simultaneously represents a nice example of an illiberal variant of NTA. More precisely, it represents an instance of what we can call a radically nationalist adaptation of non-territorial autonomy. Now, I will first let me say a couple of words about the general historical context. I will share my PowerPoint presentation. I hope it's visible. So basically, first a couple of words about Czechoslovakia. Czechoslovakia was founded in 1918 on the ashes of the Habsburg Empire, and it was composed of historically different regions and territories. So from the former Austrian part, it included the former crown lands of Bohemia, Moravia, and Austrian Silesia, as well as a very tiny part of that formerly belonged to Lower Austria. And on the other hand, from the Hungarian part, it included Slovakia, today's Slovakia, or what was historically referred to as Upper Hungary, or Feldvidek, as well as today's province of Zakarpatye in Ukraine, the Subcarpathian Ruthenia. Czechoslovakia was highly heterogeneous also in ethnic regard. Apart from the Czechs and Slovaks, the two ethnicities that you can see in pinkish tones, the state was also populated by the Ruthenes or Ukrainians in the already mentioned Subcarpathian Ruthenia. Then there was a sizable Hungarian minority along the southern border strip, smaller Polish minority in Szczecin, many Jews, which also need to be mentioned, and last but not least, the Germans as the far largest minority. Now, speaking of Germans, in the Bohemian lands, so in the western part of Czechoslovakia, there was a compact area of settlements all along the borders with Germany and Austria. In addition to that, there were also some language islands, as well as scattered groups of Germans, particularly those living in urban centers, such as Brno, Olomouc, or Prague. Previously, the Germans in Bohemian lands identified as their main identification was connected to the crown, and so there were Deutsch Böhmen, Deutsch Mähre, and the German Silesians, and so on. But during the interwar, they came to increasingly identify with a collective name, Sudeten Germans. And similarly, the smaller German minority in the former Hungarian lands came to be, that lived mostly in Bratislava, in Sips, and scattered in other parts, also came to be collectively called as Karpatendeutsche in the interwar. Altogether, the German minority, or national group, amounted to 3.2 million people, or more than 23% of the state population. Now, compared to the other countries in the region, it may be said that Czechoslovakia was relatively tolerant and accommodating towards its national minorities. They could, for example, politicians of national minority backgrounds would speak in their own languages in the state parliament, for example, and in all municipalities with more than 20% minority population, those had the right to address the state and its offices in their own language. There was a wide network of minority schools in German areas. Nevertheless, the situation was far from perfect, and most importantly, Czechoslovakia was a unitary nation state. It saw itself as a nation state and not as a nation state of some kind of political Czechoslovak nation, but as a nation state belonging to the Czechoslovak nation composed of two branches, the Czechs and the Slovaks. Now, particularly the Sudeten Germans, as the largest and economically strongest group, were not content at all with the status of being a minority in a foreign nation state. They felt this as a kind of degradation, which was not only due to their high numbers, their compact settlement patterns, but perhaps even more due to the fact that in 1918 the situation for them changed drastically. We can say that they lost their previous position that they had enjoyed for centuries within the Bohemian lands, which they inhabited for centuries. They considered them their own homelands, and they considered that they held equal right to those historical lands as the Czechs did. And as mentioned already, they were also strong economically, and in the Austrian times, in certain regards, enjoyed a privileged position as well, because for example, most of them did not speak Czech, even if they worked in public administration, whereas all the Czech public officials did and had to know German. So it was a kind of uneven bilingualism before the war. And now the tables turned, and they were not satisfied with that. And being forced to accept the new state reality, that is, after the early hopes in 1918 about annexation to German Austria and Germany got shattered, the German political leaders focused on demanding different forms of national autonomy. You can see some of these demands on the right side of the slide. Generally speaking, these demands corresponded to their settlement patterns and were of a predominantly territorial type. However, some of them also contained notable non-territorial elements. And the one that is marked in green was actually fully non-territorial, and this is also what I'm presenting today. So let us now turn the attention to the Sudeten German parties, the party that issued these 1937 non-territorial demands. It was founded in 1933, and it presented itself as a broad popular movement which united a variety of groups and orientations. Most importantly, it claimed to speak on behalf of the entire Sudeten German Volksgemeinschaft. By 1935, it succeeded in becoming not only the far strongest German party, but also the electorally strongest party in the entire state. And being synonymous with German nationalism, the Czechoslovak political elites considered the Sudeten German party to be a threat from the very outset, from the beginning. Whereas, if we try to give it a fair judgment, the situation was a bit more complex, however, because the party continuously proclaimed loyalty to the state, in contrast, for example, to the 1920s German National Party or German National Socialist Workers' Party. At the same time, however, it demanded the state to be reorganized. It did not recognize the nation-state character of the state. The ideology of the Sudeten German party, or its leading circle, more precisely, it could be labeled as far-right or radical nationalist, but not Nazi. There were Nazis present within the ranks of the Sudeten German party, but they did not have a major role. And at least until the late 1937, when the party leader Henlein made a secret agreement with Hitler, it may not be treated as an outpost of the Third Reich. The party presented its autonomous demands in April of 1937, so before this secret agreement took place, and why they did it, it was a direct reaction to the so-called February Agreement between the Czechoslovak government and the minor German parties that were represented in it, and which accommodated Germans with certain administrative measures in their favor, not, however, any kind of autonomy. The Sudeten German party decided to put forward a more comprehensive legal solution to the national question in form of national autonomy, and they came to be known as Volksschutzgesetze, or laws on protection of nationality, taking a form of 6 bills that the party put forward in the Czechoslovak parliament. Now on the slide you can see some quotes from the first of these bills, which was also most important and from which the entire set got its name. In line with it, each of the main national groups of Czechoslovakia would form a national association which would represent a person of public law. These public associations would comprise all the citizens belonging to the given nationality, regardless of their state of their residence within the state territory. Now, how this would be done? This would be done via registration, via compulsory registration of all citizens into corresponding national cadasters or registries. At the same time, the parliamentary representatives of each nationality would form the association board, and the board of the association would in turn elect a speaker, who himself, not being a member of parliament, that was explicitly forbidden, would be given the mandate to speak on behalf of the national community and to defend its interests towards the state organs as well as the other national associations. The powers of the organ of speaker and of the national association itself were not clearly defined and were potentially unlimited. The implications were far-reaching by all means, as the proposals were actually combining broad and far-reaching national autonomy with consociationalist arrangements. So there was a factual national sectioning of the parliament and also strict national proportionality in all state institutions and public enterprises, which was also foreseen in the set of bills. The tenets on which all these arrangements were to be built were non-territorial. They also contained certain visible legacies of the pre-war Austrian compromises, particularly the Moravian one, while at the same time they also contained novel elements stemming from contemporary folkish sociological, legal and political thought. This distinguished the Volksschutzgesetze from previous modern examples of NTA, which were devised for the framework of a liberal state. In particular, the 1925 Estonian law on cultural autonomy as the model interwar example. Now, let me quickly go through these illiberal traits. Firstly, the determination of national belonging was clearly involuntary, being based on a binding and essentializing definition of nationality. So, it functioned in a way that every adult citizen would have the right and the duty to declare his or her nationality and enroll into the corresponding cadastre. The crux lay in the point that this decision was meant to be a one-time and irrevocable one. It was also not entirely free one, because it had to be truthful, corresponding to the language used in family, and could ultimately be challenged and decided by a special court. But most important, after these cadastres were to be formed, and the membership in the National Association fixated and sealed, this meant that it was also fixated and sealed for all the future generations. Secondly, the scope of self-rule was considerably wider and meant to extend far beyond the sphere of national culture. It encompassed a wide array of other aspects of life that were now also considered to be essentially national, and which were also to be organized in a corporatist fashion by means of centrally coordinated network of compulsory organizations of social, cultural, or economic type. So the competences of the national self-rule were also to be extended into the economic sphere, where particularly the legal protection of the so-called national property strikes the eye. So, nationaler Besitzstand, an old nationalist battle slogan, was now turned into a legal category which was supposed to designate a concrete object to be protected by criminal law. And this was not meant to encompass only land, factories, enterprises, but even jobs. So practically that meant that had a certain workplace for a given amount of time been occupied by a member of a given nationality, it was now supposed to legally be part of its property. Now going to the third point, which is perhaps the most important and crucial one, while being given the full mandate to represent their national community and to de facto co-rule the state, these national associations did not have clearly defined and limited powers. Their governing organs lacked accountability towards members, and they were supposed to represent, as well as control mechanisms. And the national collective took a clear precedence over the individual national members, and we can say that the relationship between the two was one of essential subordination, which is a vision, basically a vision that the Sudeten German party leaders and their ideology had on civic rights in relationship to nationality rights, and which was also very much connected to their conception of nationality. The essence of which was perhaps very well captured by Theodor Feiter, whose quote you can see on the right in his 1938 monograph on national autonomy, in which he, among other, very favorably discussed the Sudeten German party bills. He wrote that basically they were an expression of a new conception of nationality, in line with which the national community possessed an absolute claim over its individual members, who could also be coerced into putting themselves at its disposal. So, essential subordination of the individual member to the national collective. And last point, it concerns the external, so to say, the external dimension of the powers that the national associations were supposed to bear. So the bills aimed basically at transforming Czechoslovakia into a federation of largely self-ruling and autarkic national communities based on personal principle, and as such they also opened a clear potential for weakening of the democratically elected central governing bodies. So if we make a clear, quick comparison to, for example, Karel Renner's objective was strengthening the common state framework by neutralizing nationalisms, something that also Matthias touched upon briefly, they aimed at the opposite. They aimed at strengthening the nationalisms, and the state parliament, for instance, would have been transformed from a common popular representation deciding on the matter of common good, or what Renner would have called the staatsbildenden Interessen und Faktoren, into a kind of a place of bargaining between particular national interests. So in this way, the state sovereignty would be weakened and potentially undermined. In fact, if we look at the statements made by the framers of the bills, as well as the legal theories that underpin them, the non-territorial national groups themselves were now perceived as the basic carriers of political will that preceded the state itself. Which was connected to the ideas that transposed the notion of popular sovereignty from citizenries of individual states, so from demos, to individual ethnic groups within them, but potentially also beyond them, as pan-state Volksgemeinschaften, for example, where we have a very nice quote from one of these theoreticians who was also directly involved in framing the Sudeten-German party bills, Hermann Raschhofer, who said that basically the abstract people of Rousseau in Central Europe of 20th century concretized itself in an ethnic way. And in this connection, it also needs to be mentioned that the Volksschutzgesetze were a product of a broader endeavor that took place on the international level of European minority activism, something about which also a topic on which Marina touched upon in her presentation. So, and the key role in this endeavor was performed by the so-called Volksgruppenrechtler, or nationality lawyers. Those were mostly German-speaking legal experts that were engaged in developing special legal framework for ethnic collectivities on sub-states as well as interstate levels that would ultimately be integrated into international law. And they belonged to different strains of far right and were all highly critical of what they called Western formal democracy, whereby it must be mentioned that most of them, including Hermann Raschhofer, through the course of 1930s became Nazi fellow travelers, if not outright Nazis. And ultimately, this endeavor of Volksgruppenrecht got instrumentalized by the Nazis during the World War II, which particularly manifested in the special legal statuses enjoyed by those Germans who were citizens of allied states such as Hungary or Czechoslovakia or Croatia, or occupied territories such as Banat, for example, and also territories in process of annexation where you have different levels of citizenship. So here on the slide you can see an ID of a person that was belonging officially to the German ethnic community in general government. So the occupied Poland, this is on the left, and on the right you see one page from a similar ID, but from the occupied Banat, which was officially belonging to Serbia, previously Yugoslav Banat. And this, why I'm mentioning this, because I see this World War II instrumentalization of nationality law also as a culminating point in an illiberal trajectory that collective ethnic rights experienced during the 1930s. And Volksschutzgesetze, in my opinion, can be seen as an important station, if not a turning point, in that broader story. It can also be said that they, in a way, stood halfway in terms of how far this illiberal renegotiation of national autonomy could have led, and in some ways did lead. Because, at least nominally, they still operated within the democratic framework of the Czechoslovak constitution. Also, they were folkish, but not racist, at least not openly. They did not introduce hierarchical relationships between particular nations or speak about separate legal systems for them. And moreover, they also had a particularistic focus on the so-called Sudeten-German national group, which meant that they were not fully in line with the National Socialist integral pan-German outlook. However, what does their case show us? I think it can be very instructive because it shows us the basic ideological openness and flexibility of the idea of non-territorial autonomy and its adaptability to various agendas, including potentially far-right ones. It reveals the illiberal potential generally inherent to group-focused approaches at accommodating diversity, And while this potential should never be mistaken for inevitability, they can nevertheless serve as an instructive example for contemporary debates concerning challenges connected to multiculturalism, politics of identity, and especially illiberal communities within liberal societies. So thank you very much.
Thank you so much, Oskar. We have 5 minutes for any remaining questions. Questions on Oskar's paper or general questions pulling the different papers together, please. Yep.
I, again, very much enjoyed the presentation. Thank you very much for sharing all this information. When assimilating the information which I received, I realized that there are many interesting things, again, which become clearer and understandable regarding many problems we discuss within NTA and consequences. So you have highlighted this very well in your concluding remarks, that what are the potentials of illiberalism in those things. Now, I just would like to highlight 2 points, and also I don't want to challenge your conclusion, because I think it is well justified, but I just would like to provide a perspective of some of those things from the perspective of practicing minorities. So what are the problems which are? So the one thing is not related to. It is just an interesting thing which we encounter in several aspects. The issue in whether the community, so this is a liberal communitarian debate, whether the individual is for the community or the community is for the individual. And it is so interesting where you highlighted that there was a claim that this corporative institution which speaks in the name of the community should have a precedence and should oblige members to certain. Now that is a very interesting aspect, because in contemporary national cultural autonomy attempts, it is a very, very difficult problem how you can assure internal democracy and yet reach efficiency of the organization, so that exit or speaking against the central authority allows those organizational institutions to be efficient enough. Now, finally, what I would like to say about these dangers of illiberal consequences of NTA, I think that it would be worth taking into account that those associations, or the whole idea of NTA, in order to be effective, needs agency. Yes, and I think that all the things you mentioned earlier, I think should be, to the list you mentioned earlier, this thing has to be added, that in many cases the rationale behind this illiberal so to say, deviations of the project come from this need of becoming effective agency and the capacity to have a structure of decision-taking and the capacity to speak in the name of the whole. So that's very, very interesting. I think it is also, so it was interesting to see that this philosophical problem has had a very sharp, clear formulation in a concrete historical moment. So I'm very much grateful for these insights you have offered us.
Thank you. Thank you for very insightful remarks. I very much agree.
Okay. Anything you'd like to add now? One final question, if there is one out there. Anybody? No, in that case, we'll stop. Our time is up. We started at 7 minutes past 1. So just remains for me to say thank you to you all for what I thought was a wonderful panel, and so many interconnections between the papers. I mean, you know, it bridged the route from the original NTA through the interwar period, through the Soviet Union, to the issues that have flowed from that legacy. So, yeah, really nice. Thank you all.
Thank you for attending. I'm sorry for